All rise.
Court of Appeal in and for the 6th District of the State of Florida is now in session. The Honorable John K. Stargill, Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to our last oral argument day of the year. Happy holidays to everyone. And this is also our first oral argument experience here at the Lake Alfred complex, and we're looking forward to doing it. Want to say thank you to the 10th Circuit for allowing us to use their facilities. And we have two cases this morning that we're going to be discussing. And the first one, let me just say, as far as electronic devices, anybody that has them, please turn them to stun or turn them off so that we don't have to hear what is going on. And we're going to start this morning with the Department of Agriculture and Consumer Services versus Gary Mahan. And each side will have 20 minutes. If you want to let me know how much you want to reserve when you come up, then we'll notify you as such. And so we have, is it Mr. Parsons? Okay.
Thank you, Your Honor.
Okay. And for Gary Mahan, DBA Pokies today?
Yes, Your Honor. Ryan Reese.
Ryan Reese. Okay. All right. Well, Mr. Parsons, no one has any questions, and you're recognized to begin.
May it please the court, Wes Parsons for the Florida Department of Agriculture, the appellant and cross appellee. I'd like to reserve 5 minutes for rebuttal, if I may. This case is about a statute enacted by the Florida legislature in 2006 to save the Florida nursery citrus industry. The industry had been under attack by pests and diseases for many years. And there was a sense in the industry that something had to be done to be sure that citrus that came out of nurseries in Florida remained clean, that is healthy, so that a commercial grove owner or a dooryard, a residential owner could be sure of acquiring clean, healthy citrus before the inevitable assault by pests and diseases in Florida. And the legislature accomplished this by the enactment of Section 581.1843, which required the enclosure of citrus nurseries in Florida to prevent two specific diseases, citrus canker and citrus greening. The enclosure statute had a phase-in period of 18 months. That is, it was not imposed immediately. All citrus nurseries had a period of 1.5 years to come into compliance with the statute by building enclosures, which were typically affairs of screening, wood beams with positive pressure doors to make sure that insects and to some extent rain could not get inside the nursery.
So I know you're going to get to the Penn Central factors, and I may just be beating you to the punch, but when we talk about the gradual nature, the phase-in nature, it seems like that may matter or may not matter at all. And to me, it kind of depends on this. When do we measure the value of what was taken? We obviously have the value of the citrus prior to the regulation, and then we have the value of the citrus after the regulation. Do we determine that post-regulation value at the time of the enactment of the statute or at the time the citrus is destroyed?
The time the citrus is destroyed. Well, the sense is that it is a loss to the owner, and that loss is determined at the time of the loss, just under general principles of law. So if this loss occurred in February of 2008, that was after the statute had been enacted and after the deadline of January 1st, 2008, which made it illegal to sell or distribute citrus in Florida that was not grown in an approved structure. So at the time of this loss, this was basically contraband. It could not be sold in Florida. It was illegal. And that is one reason the citrus had no value, Your Honor.
No, I understand that, counsel, but could there not be facts in a particular case, possibly in this case, that shows a substantial devaluation of the citrus immediately after the passage? Opposing counsel talks about fire sales. Obviously, there's costs of coming into compliance. Why would we not measure it immediately after the regulation takes effect and Mr. Mahan in this case takes a hit? Because he obviously suffered a hit of some sort immediately after the regulation, not just at the time of destruction.
Well, he did. I suppose one cannot neglect the phase-in period. It was in Mr. Mahan's hands as it was in the hands of every member of the citrus nursery business. They were in an extremely heavily regulated industry. There had been many regulations before. We had gone through the citrus canker eradication program where 10 million citrus trees in Florida were destroyed. Anyone in this business knew when they entered the business, they were entering a highly regulated business. Here's another regulation coming down the pike. It's addressed to a disease that everyone in this industry in Florida knew had to be taken into account.
Can we talk about the history of Florida's attempts at eradicating this disease? Because it does seem the program that you just mentioned that took place in the 90s, there did seem to be a compensation component that came along with that program. Should that factor into Mr. Mahan's expectations, whether or not he had a reasonable investment-backed expectation?
Well, any reasonable expectation would be by the grace of the legislature. By the grace of the Florida legislature, compensation was paid to homeowners of either $55 or $100 per tree in the citrus canker eradication program. And the United States Department of Agriculture also paid compensation to some commercial growers, but not to nursery owners. So perhaps Mr. Mahan would have an expectation the legislature would act, but that is purely by the grace of the legislature. It's not a legal right that's cognizable in eminent domain law, Your Honor.
Here's from my reading of the case that the only reason why that statute was dealt with in any way favorably, some of it was stricken, some of it was not, was because the analysis was completely under the Florida Constitution and the idea of taking a property without just compensation, because the legislature had put $1,000 per acre into the law. The court said, essentially, good start, but that's not even enough. It still needs to go to a jury to find whether that is truly just compensation. But to me, that's a completely constitutional analysis, which would then go contrary to what you're saying, which is always in the grace of the legislature. That's not the language I'm reading out of the State Plant Board versus Smith.
There are two types of cases recognized in inverse condemnation law: physical taking cases, and that's a physical taking case, and regulatory taking cases. And Mr. Mahan chose to bring a regulatory taking case. He said the regulation had diminished the value of his citrus, in fact, eliminated it. And under a regulatory takings case, we don't do a Smith type of analysis, respectfully, Your Honor. You do a Penn Central analysis, as you've pointed out, Judge Nardella, and there's three factors: the factor of reasonable investment-backed expectations, the factor of economic impact upon the owner, and the factor of the character of the government action. Judge White analyzed each of those factors. We have no quarrel with any of Judge White's decision-making. It was impeccable. All of his facts should stand. We do disagree with the legal analysis of each of those three factors, because in each case, Judge White found the factor favored the owner and not the department, except to the separate issue of the 400,000 seedlings. And the law has evolved since then. It's evolved in a direction that more account is taken of the need for regulation in a heavily regulated industry, such as citrus agriculture. There was the Orlando Bar Group case, which regulated alcohol sales in restaurants. There was the Darcy case, which involved parimutuel gambling, a heavily regulated industry. There was the support working animals cases, also the same. And even going back even further, which in this case was before Judge White, There is the Galaxy Fireworks case, which involved the heavily regulated industry of fireworks. And what those cases say over and over again is the most important factor is this a heavily regulated industry? If it is, then the legislature is entitled to act without the imposition of liability to protect that industry. That is what the Florida legislature did in this case. It wasn't taking from the industry to benefit someone else. It was imposing a burden on the industry to benefit the industry. And that's sort of, it's very much like the Darcy case or the Orlando Bar Group case in that regard. Judge White did not see it that way. He did not have most of that case law before him. His view was simply, Mr. Mahan owned the citrus. He owned 176,000 trees. Therefore, he had a reasonable investment-backed expectation, period. He did not, quite explicitly, did not consider the heavy regulation of citrus agriculture in Florida.
Isn't a difference between the Darcy case and they came down and said, you can still race dogs, you just can't bet on them. There's still a use there. Here, there's no use for these trees at all. They had to be destroyed.
Well, that's the nature of a regulatory taking case. The regulation can be rather harsh, as it was here, or it can be rather mild. Darcy was somewhat in between. In this case, it was harsh in the sense that Mr. Mahan lost his trees, but it was very lenient in the sense that he could have prevented all of that damage simply by selling his inventory before the deadline or by complying with the statute, as almost every other citrus nursery owner in Florida did.
So Judge White made some findings and you've acknowledged that. You agree with the facts, but should it be considered the fact, I mean, the legislature passed a statute and basically they had to get rid of all of their trees within a period of time. Basic supply and demand tells you there's going to be some loss and maybe the market can't absorb all of these trees being dumped at one time. Aren't these also factors that should go into takings analysis and why he has a
I would
loss?
disagree about the dumping analysis. What most nursery owners did is enclose their citrus. That's what you did. Yes, there could be short selling. There probably was. I think the general sense was, and this may be in the record, that citrus prices rose after the enclosure requirement because there was a slight burden in terms of building the enclosures, and that increased the cost of production. So again, it was a trade-off. The industry decided that it needed to protect its stock, its inventory, its basis for its existence, and it did so by raising the price of citrus to include the enclosures.
Counsel, the liability court found that Mr. Mahan could have complied but did not. That's an important finding for you. What is the competent substantial evidence to support that finding? Just one.
Well, sure. Mr. Mahan took out $1 million loan to comply, and he built 2 structures. He didn't build as many as he needed. And when he was asked why, he said he thought the regulation was going to go away, and he ran out of time. So that was his explanation for it. Every other nursery owner, except for Mr. Mahan's brother, was able to comply.
Right, and I recognize that, but are there any hard facts? Did he wait too long to go to the bank? Was he unable, could he have gotten a larger loan? Did he not hang on his general contractor enough? I mean, are there any hard facts that he actually could have complied timely?
Well, for example, a supplier of Pearson Supply was called. They sold the screening, and at one point, Mr. Mahan said, "I had trouble getting screening," but the representative at trial said, "No, we had screening available throughout." It was, these structures are not complicated. He simply didn't do what he was supposed to do, and if he had, he would have suffered no loss at all. Going through the Penn Central factors, which the panel seems interested in. The last factor, and this is very important, is the character of the government action. That is this really important to the government that the regulation be imposed? The way Judge White saw it was citrus agriculture is not that important in Florida. He said that. He said that what is important is human life, protecting human life. And there are a few eminent domain cases out there where human life is at stake. No doubt that is a very important consideration in some cases. But again and again, the Florida Supreme Court and the district courts have said the Florida citrus agriculture is the signature industry of Florida. It was at one time, may still be our second largest industry. Thousands of people's jobs depend upon it. It contributes billions of dollars to the economy. It's really important. The legislature is entitled to use its police powers to protect agriculture. And for that reason, we respectfully submit Judge White got this point wrong by disregarding those authorities. This should have cut in our favor, not Mr. Mahan's favor. The other factor is the economic impact upon Mr. Mahan. We've discussed this somewhat before. Judge White said, I'm going to see what percentage of the citrus trees were destroyed. Well, it looks like 87% were destroyed. That's a significant impact. Well, that's fine as far as it goes, but of course there was a phase-in period again. There's case law and eminent domain law about phase-in periods. Legislatures can use those to prevent a harsh impact of a statute. There's a Meritrans case on the federal level where oil tankers had to be double-holed, so there would be fewer oil spills. But there were a lot of single-hold oil tankers around. And and of course there was a lawsuit because the owners didn't want to double hold the oil tankers, but there was also a phase-in period where the single hold oil tankers could be used for a while. That was enough to save that statute from imposing liability on the government in that case. That's on the federal level. On the state level, there's a case from South Carolina. There's a case from Maryland. One involved automobile emission devices. There was a phase-in period for enhancing their use on automobiles, and that saved it from liability. In the other case, which involved video poker machines, they were banned, but there was a phase-in period for that ban so that the owners, which were typically 7-Elevens and such, could phase out the use of those machineries. So this phase-in period wasn't something the Florida legislature just came up with willy-nilly. It's a part of takings law that's designed to immunize a government entity from having to be liable for in these sorts of situations.
You're at your 5 minutes.
Thank you. Thank you very much, Your Honors.
Good morning, and may it please the court, Ryan Reese on behalf of the appellee cross appellant Gary Mahan. I want to start by addressing issue 1, which is the trial court's liability analysis that Mr. Parsons just discussed. But before I do, I'd like to take the court through a survey of the binding precedent in the state of Florida as it relates to citrus takings and the unique protections afforded healthy trees that are destroyed pursuant to regulation. And what I think that'll do is it'll inform the court that a lot of the arguments that you've heard from the department as it relates to the liability finding are really variations on a theme, variations on a defense that the department's been advocating for 70 years. Okay, and that is in essence that we're here from the government, we can destroy your healthy trees because we're protecting the industry. And that has been categorically rejected by the Supreme Court numerous times over the last 7 decades. It started with the pull and treat program that the department implemented in the 1950s, said that it was a required burning of all trees within a perimeter of an infected tree. The department said we don't have to pay for the healthy trees because it's the police power. We're regulating for the public welfare. And the Supreme Court said twice in 2 different decisions, yes, you do have to pay when healthy trees are impacted. That's the Corneal decision and the Smith decision in 1957 and 1959, respectively. And from those 2 cases came 2 important determinations. Number 1, the court said it is inescapable that the destruction of trees is an appropriation for public use. Number 2, that the police power, though broad, is still, use the word, fenced in or constrained by constitutional limitations, such as the right to compensation, and that the absolute destruction of property is justified only in the narrowest limits of actual necessity.
Does it matter that Mahan destroyed these trees instead of the state?
It matters not. It matters not. Same case, similar facts in the Reed Brothers case, Connor versus Reed Brothers in the 1990s. There, it was the property owner destroyed the trees because the trees were in essence quarantined as a result of the regulation in effect.
What responsibilities do you see, Mr. Mahal, as far as mitigating? A big deal about mitigation and the time frame that you highlighted.
Yeah, and this case is unique in that there was what the department calls a phase-in period. But ultimately, the mitigation of damages theory, whether you look at that through mitigation of the doctrine of avoidable consequences, that's a product of tort law. There's absolutely not one inverse condemnation case that says a property owner has an affirmative duty to mitigate their damages. The reality is, most property owners can't afford to get to the stage where they go into non-compliance, right? Either due to a fine or criminal penalties. So they comply and then they sue after the fact. This is unique in that Mr. Mahan waited until the deadline and was cited for a violation. And that triggered, his standing to present the case. Similar case directly on point from the United States Supreme Court was the Horn case, United States Department of Agriculture v. Horn. It was a requirement from the federal government that raisin growers had to set aside a percentage of their crop to give to the government for subsidy and other private uses. And they, like Mr. Mahon in this case, were cited with noncompliance by deliberately disobeying the new regulation. And so, there's not one citrus case that says in the state of Florida that looks to what the owner could have done or should have done with the property that's destroyed prior to enactment of the regulation.
Counsel, I'm going to pose you the same question I posed to your colleague. At what point in time do you measure the economic impact?
So I agree with counsel, and this is just fundamental law of eminent domain, that the damages for the taking occur or are paid at the time of the owner's loss. But that's not to say that the economic impact prong of Penn Central doesn't play into the calculation of the cost in complying with the government regulation, right? So here there was a ton of testimony. He borrowed $1 million to try and enclose 35 acres of citrus. He had, 18 months to do it. He borrowed money to do it. He attempted to comply. He sold. He took $30,000 just to advertise his citrus so he could, sell it as quickly as possible because he didn't think that he could keep the citrus that was presently being grown outside between 2007 and 2008. So while the damages are paid at, based on the date of.
But is that not a different question, what the damages ultimately are for compensation purposes versus the Penn Central factor of economic impact? Or are they tied? Not just tied, are they the same question?
So if I understand your Honor's question correctly, is, a lot goes into, especially with a phase-in period here, a lot goes into the economic impact evaluation, looking at the owner's circumstances, right? Takings cases are very ad hoc, they're very fact specific. So here the trial court looked at what did Mr. Mahan have to do to try and comply with this regulation? We did all the things I just said and he still was unable to comply. So those circumstances play into what the owner's economic loss, what his economic impact really is. The economic
Right.
impact is different than the loss.
Understand. And the liability court certainly did consider how onerous compliance was. They certainly did. But they seem to rest the economic impact analysis on the framework of the ratio.
Yeah, and the calculation was easy. It's, City of Venice versus Gwynn, second district case says you measure the property before the regulation goes into effect, you measure it after. And that's the difference in value.
Isn't that different than measuring it at destruction? Because the ratio measures at the destruction point, not at the time the regulation takes effect. And that's what I'm trying to figure out for the Penn Central factor, is where I measure the economic impact.
Well, you measure the economic impact at the date it's destroyed. I mean, the reality was up to the date of the department's required destruction pursuant to its own regulation. Mr. Mahan had valuable property and then he had no property. So it is a categorical taking of all that citrus that was destroyed. it lost all value.
This stat, under your analysis, I mean, given even a longer phase in, but even during this period, everyone's on notice not to continue to develop new product unless it's covered. Going forward, if we award damages to anyone who say, well, I tried, but I couldn't sell it, your position is that they get 100% and there's no reduction at all for the mitigation that they didn't try.
If there were, it would be a question of compensation. It wouldn't be a question of liability. Inverse condemnation law there's not a case that I'm aware of that looks to see whether, and the department cited none, that looks to see what steps a property owner took to mitigate their damages. It's just not there in the law of inverse condemnation.
400,000 trees. We haven't talked about that yet.
Sure. So, and that's the central issue on the appellant's cross appeal or the appellee's cross appeal. The trial court essentially relied on two findings, two determinations. One was that there was competent substantial evidence in the record that demonstrated that Mr. Mahan had planted that segment of his crop, the 400,000 seed plants, after the January 1, 2007 date that the regulations went in effect. Alternatively, seemingly unsure of that ruling, the trial court found that even if that wasn't the case, even if the record didn't show that he'd failed to meet his burden on that issue. And we contend that both of those findings are not supported by the record. As to the first, there was no competent substantial evidence that Mr. Mahan offered by the department that Mr. Mahan planted the seedlings after the January 1, 2000.
Wasn't there testimony after the apology?
Yeah, so
So I'm confused. Why does that not matter?
so it's not competent, number one, and I think the record's clear on that. The testimony regarding the age of the plants that were pointed to in the picture that I believe your honor's referring to came from the department's structural inspector, who admitted on cross-examination he was not a citrus inspector. He was not there to inspect Mr. Mahan's citrus and did not, in fact, inspect Mr. Mahan's citrus. Yeah, I think at the trial, he pointed to some pictures that showed a certain size of certain plants for the inference that was ultimately raised in closing argument. Well, those couldn't have been much more than 3 or 4 months old.
So if it's Mr. Mahan's burden and we have Mr. Mahan's testimony and the liability court is disregarding Mr. Mahan's testimony, what does Mr. Mahan have?
So we don't know why the trial court disregarded Mr. Mahan's testimony.
Didn't the liability court tell us that they didn't find him credible because of a past?
The trial court said that the judge was rejecting his testimony. They did not provide a basis. Now, it's inferred from prior questioning and closing argument that it was on the issue of credibility, but the reality was he wasn't impeached on this issue. The felony conviction was brought out in direct. It didn't go to truth or veracity.
There's even dialogue between counsel and the court where they talked about these things. They even went into the issue of, doesn't he kind of have a reason to be untruthful here? Because if he planted all of those with an attempt to up the ante for possible takings.
And I think the Walls v. State case hits that pretty squarely, says that the trial court cannot reject uncontroverted fact evidence, which this was fact evidence, unless contrary to law, improbable, untrustworthy, unreasonable, and contradictory. Now, so here we're going to...
Equally untrustworthy.
It's inferred...
Credibility is not there.
It's inferred from the colloquy between the court and counsel that there were concerns from the bench on credibility. It's not expressed in the trial judge's ruling. And another, why would the trial judge find him credible on other issues and not as to the date of planting as to the citrus seeds? It makes no sense at all.
I was a trial judge. There was numerous times where I find parts of somebody's testimony credible, and other times where it's not credible. I don't understand why you have trouble seeing where a judge can hear someone say something and it's in their best interest to say it. So
it's not expressed that he found him untrustworthy as to that particular issue. And I think for this court's review, that needs to be a finding that's made in the record. Otherwise we don't know if the trial judge found him uncredible or he just didn't like the shoes he had on that day. Now that's an extreme example, but you don't know, right? So that's why, and this is the difficulty with doing an oral ruling, at the close of closing argument and not having a comprehensive written order. The parties did that at the court's request, but it's not clear in his oral ruling at all. Never once does he find him untrustworthy. It's not in there. And in any event, we would contend that the error was compounded by not allowing Mr. Mahan to reopen his case. The case on that issue is the Greg Garcia case. I think it's somewhat acknowledged that
I think it's in the judge's discretion to decide whether to reopen the case.
it's certainly in the judge's discretion. That's the standard, is abuse of discretion. But here we met all four of those factors. We met the timeliness, character, the effect of the omission on the case was catastrophic for Mr. Mahan and non-prejudicial to the department at all. And the reasonableness of the excuse of not raising it prior to the close of closing argument was that this hadn't even been an issue. The question of Mr. Mahan's ownership of these plants and when they were put in the ground was hardly even an issue. The questions from the department's counsel were just, when were you said, Mr. Mahan, that you planted these prior to 2007. Yes, these were in the ground in 2003, 2004. That's accurate. There was no further questioning. He wasn't impeached on it. He wasn't even impeached with the felony conviction. We would contend that the case was decided on the basis of procedure and not on the merits. 15-minute evidentiary hearing would have solved, this issue entirely. And I know the department says, well, the testimony would have been cumulative. Mr. Mahan would have had an opportunity to offer other witnesses on this very issue. In fact, we proffered Mr. Mahan's testimony, and then post-trial depositions were taken of nursery employees that said, this crop was all planted in the ground. So we would contend that it was an abuse to not allow Mr. Mahan to reopen the case. With my remaining time, I'd like to circle back around to the liability issue and just stress that in Florida, citrus is treated with great constitutional protection. I mean, the law from the Supreme Court, from Cornell, Smith, Mid-Florida Growers in 1988, Polk 1990, Hare 2004, Patchen 2005. The state cannot destroy healthy citrus without compensation.
Prior to this section, 2006, that the state of Florida has never taken compensation.
That's accurate. And I think that's evidenced by Your Honor's questioning earlier, was that the department recognized that they needed to pay compensation when they destroyed healthy trees and exposed but not expressly infected trees. And that's why they implemented a compensation mechanism in the statute. I mean, the department's been fighting this issue on the same grounds that, we have the ability to destroy healthy trees for the public good. That's been categorically rejected in nearly every case. The Bogorf case in 2010, the Mendez case in 2013, both by the 4th District. It's, I think, fairly cemented in the law, and it's binding law to this court that, when healthy trees are destroyed, compensation is required.
Make sure I get your answer to this today. And I know we've touched on it a little bit, but when we talk about Mr. Mahan's diligence, opposing counsel cites Maritimes. He also cites the South Carolina case, Westside Quick Shop versus Stewart. What are your responses to those cases, which certainly do seem to analyze a lapse in time, a gradual phase in?
Yeah, my answer is twofold, Your Honor. Number one, we don't need to go outside the state of Florida to look at cases on regulatory takings, because we have a significant body of law here in the state of Florida on citrus destruction for public use. To the first question, what impact, if any, does the lapse in time have? This is a unique case because there was a phase-in period. The only other case that either of counsel have cited is the Meritrans case. And in that case, the Federal Circuit didn't find, dispositive that there'd been a period of time that elapsed before the regulation was enacted and went into effect, and that, the owner just didn't comply. It looked at that solely on the economic impact factor. What could that ship owner have done? Not what could they have done, what did they do in terms of retrofitting their barges, selling their barges on the open market? It wasn't what could they have done, it was what did they do. So they looked at the actual circumstances.
What could they do? The phase-in gives them an opportunity. And why should the law not look at what could be done with
Well,
that opportunity?
The trial court here did look at what could be done, and there was conflicting evidence as to what Mr. Mahan could do at all. The department testified that it could be sold to Canada. The department testified that it could be sold to Canada. That was conflicting and rebuked, we believe, by the owner's witnesses and on cross-examination. At the end of the day, it all goes to the owner's economic impact. And here, that along with what that owner had to do to comply plays into the equation. That's why it's Penn Central, their ad hoc factual inquiries. You got to look at, what steps would this owner have had to have taken to comply? It would have spent millions and millions of dollars in closing 35 acres of citrus. And as it relates to the owner's investment-backed expectations, that was unprecedented in the state of Florida. I think that that's no more unique than the state of Florida passing a law saying that all homeowners with pools have to enclose their pool screens due to, the influx of mosquitoes in the state of Florida. This was just categorically unprecedented. No owners expected it. And at the end of the day, these two particular owners, Gary and John Mahan, didn't comply, and it isn't relevant to the Penn Central analysis. I see I'm short on my time here. We would ask that the trial court's liability determination with respect to the 160,284 trees be affirmed. We would ask the court reverse the trial court's liability determination, finding no taking as to the 400,000 seed plants. Thank you.
Well, let me address Judge Smith's point about whether there is a Florida case which finds healthy citrus to be non-compensable. The case is Florida Department of Agriculture versus Polk from 1990, 568 Southern 2nd 35. This was, again, a commercial nursery case, and an earlier strain of citrus canker called nursery strain citrus canker had become present in Florida nurseries, and the department had embarked on an eradication program. In one of these cases, the Polk case made its way up to the Florida Supreme Court, bypassing the district court. In this case, there was healthy citrus, that is, citrus that did not display visible signs of infection, but was within the exposure zone, that is, nearby actual infected citrus. And the Florida Supreme Court, on page 40, note 4, held that this exposed citrus was simply not compensable because it was too near the infected citrus. That
I will look that case up after that. I'm not familiar with that case. In that case, did the trial court make a finding that no compensation for the trees?
I believe it was the opposite. They did find compensation. It was reversed. I want to retract that statement. I'm simply not sure, Your Honor.
To me, that tends to be a line that I see in a lot of these cases is the judicial discretion appears to often be upheld in situations like these. And I'm not saying that, the whole point of appellate review is to look at whether the judge has somehow gotten it wrong, so to speak. But I do find that the cases, especially Florida cases, tend to uphold the trial courts. And there's one particular case that I did want to zero in on. It's a couple, but the first one would be the Galaxy Fireworks case. And my question to you, counsel, on Galaxy Fireworks, that was an interesting circumstance in the state of Florida where it was very dry for a certain period of time, and for a period of approximately, I'll just roughly estimate 14 days, fireworks were not allowed to be sold for the safety of the state. Would the outcome of Galaxy Fireworks have been different? And oh, by the way, the the court said fireworks, as we all kind of know, heavily regulated. Of course they are. They should be. There's a lot of safety issues with fireworks. But if the law would have said the state of Florida now finds fireworks are not allowed. All fireworks companies, all fireworks retailers must take their fireworks and dump them in a bucket of water and destroy them. Would the outcome of that case been different?
Only if it were supported by the science. If in fact, Florida had permanently entered into a dry season where wildfires were expected, to be ubiquitous, then I think the Florida legislature could do so without compensation.
What science could possibly support a ruling? And the reason why I say this, counsel, is when I read cases like Galaxy Fireworks, I look at the second to last paragraph, which says the temporary limitation on the sale of fireworks under these facts does not rise to such an interference with investment-backed expectations as constitute principal taking. So because we're only talking about 14 days that you can't sell fireworks, they say that's not enough. They didn't say, and this is, I think, critical to I think would go contrary to what I believe is somewhat the argument I see in the brief. They did not say, because it's heavily regulated, therefore the government can do whatever they want and take whatever they want and destroy whatever they want. They didn't say that. They actually said that even within the construct of heavily regulated industry, there still was a potential of an investment-backed expectation, which then takes me to my next question, which relates to another case that you relied upon, which is the support working animals case, the Greyhound case is what I wrote. And in that case, the court went through this analysis where they said that at one point in time in 1930s is when this sort of gambling became legal, and therefore anybody that buys a racetrack of dogs, it's something within the gambling industry, must be prepared for the legislature with the same stroke of pen to say, we're not allowing this anymore. And that's exactly what happened with the Greyhound racing. Stroke of the Constitution, and it wasn't allowed anymore. And according to federal court this time, no compensation. And my question to you would be, when in the state of Florida has it been illegal to grow an orange tree?
Let me go back to the beginning, Your Honor. I think I agree with you in that simply because an industry is heavily regulated doesn't mean any regulation for any reason can be forever imposed. There has to be a rational basis for the exercise of the police power by the legislature. Going to Galaxy Fireworks, the length of the ban was simply functional. It lasted as long as it needed to deal with the dry season in Florida. If there had been a longer dry season, there could have been a longer ban. If somehow, as Your Honor's somewhat extreme hypothetical entertains, if there had been a permanent dry season, perhaps there could have been a permanent ban. Those are the only situations I think that would justify a permanent ban. But of course, we're not dealing with that. We're dealing with a situation with fireworks where we only need a ban for a period of time. Kind of analogizing now to the situation we have in Florida, we have diseases which are now endemic in citrus canker and in citrus greening. A permanent ban on growing citrus in nurseries that is not within an enclosure is necessary. It's not going to change. Perhaps someday we might breed a better resistant type of citrus, but that day is not here yet. So we do need, in a sense, a permanent ban in citrus nurseries. Going back to support working animals,
You're past your time, but you can finish up at this point. And
I think it's basically the similar sort of analysis, Your Honor. In eminent domain law, the distinction between permanent takings and temporary takings has generally eroded in the last few decades. At one point, a temporary taking was not even compensable. It certainly is compensable now. You can take a time slice, a taking of certain rights in certain property for a certain period of time, and in some circumstances that can be compensable. Likewise, the fact that it's a permanent ban doesn't necessarily mean that it is immunized or not immunized as compared to a temporary ban.
thank you, counsel.
Ask for reversal. Thank you.
Very interesting issue and good arguments. Next on the docket, we have O'Hare versus O'Hare. You know, a couple minutes to switch places in.
Mr. Jeffrey Murray on behalf of my.
Welcome. Earlier, whenever we announced this is our holidays, it's our last oral argument session of the year, and thank you all for being part of the first day that we've had arguments here at the County Government Center here in East Polk County. So, if you have any feedback afterwards, things that we can do different, then please get it to our mark. We're excited to be here. And Mr. Sessions, you're recognized.
Yes, Your Honor. I'd like to reserve 2 minutes, Your Honor.
And my own feedback is I didn't know what to expect when I got in the car, and it's a beautiful facility. So
Yeah.
glad to be here.
And spot early for facilities.
Absolutely. As I said, may it please the court, I have the privilege of representing Mr. Mark O'Hare. And this is a very dramatic set of facts when you look at the record, but the facts, because of the timeline, which I'll allude to shortly, really have no legal relevance in terms of what the finding was. The finding really turned on Judge Spor's finding that this agreement was void at the time, pen touch paper, I think, to use her verbiage from her transcript, which is very short, and we'll talk about that. However, the case law and the rule is clear. At most, this judgment would have been voidable. So we would ask for de novo review. We believe the court misapplied the one case that it cited to, Castro versus Castro. But in terms of background, these parties were married in 1981. They had a long-term marriage that produced 2 children. One son was a pro golfer who, if you're a golf fan, you know who he is. And a little more than 28 years later, the parties divorced. At the time of the dispute, at the time of the final hearing, it's not in question that my client had a pending Social Security disability claim. He was ultimately determined to be 100% psychiatrically disabled. He has chronic depression, he has anxiety, he's bipolar, and he suffers from something called explosive disorder, which we'll see in full effect in terms of the record. This was very much known to the former wife. There's not any fraud, despite the argument by opposing counsel. The judge made no finding of fraud, even though that was pled by the former wife.
So it appears to me that your main argument is that the trial court misunderstood that it's the rules of civil procedure which govern the former wife's motion for relief as opposed to the case law that she cited.
The family law rules of procedure, yes.
Correct, which is also 1.540 plays a large part into that, but yes, 12.540, you're correct. If we were to accept that as true, would we remand for the court to then analyze the claim under 12.540?
You would reverse because the record's clear. It's not in dispute.
Yes, counsel, if we accept your argument, then we reverse. The question is, does the
I'm
trial?
sorry, reverse and remand for a ruling that events that happened 8 years prior to the supplemental petition that was filed in this case, or the motion that was filed later amended, has no legal effect in terms of it's not a voidable judgment in any way, shape, or form.
The former wife's motion did cite the rule. She did cite 12.540. So what I'm asking is, does the trial court now go back and accept their premise? They did not originally consider the wife's motion for relief under the rule for those reasons. And it's not why not.
My position would be that there's no basis based on the record for any sort of additional factual review. The facts have been fully litigated. The three provisions in 12.540B that might apply were: one, fraud was specifically pled. However, fraud has to be brought within a year. That didn't occur here. It has no basis for having been pled at
I'll come
all.
back to that in a minute, but I want to hear your other.
The other one?
You wanted to list three things, but I want to come back to that point in a second. So.
Okay. The other one was that the judgment is void. We know that the judgment is at most voidable. There's a Florida Supreme Court case that's directly on point that is precedent for that position, and we'll talk about that. And then the last one that was asked for was 12.540B5. The motion, one must, I'm sorry, 5, that it is no longer equitable that the judgment should have prospective application. However, the case law is clear that has to be on events later, not events back in time to.
Couldn't the
vote your
events
sense.
there be the knowledge that came out later about all of the things that were going on at the time?
It didn't come out later. The former wife knew of it. It was litigated later. It was litigated far later. The last
Well,
action.
Right, and I understand your argument that 8 years is too long. You can't go back and have this removed, but this is talking about perspective. If, assuming, as Judge Nardella has said, we do reverse and send this back, you're saying it has no effect whatsoever, the fact that the extreme facts that you're talking about, I mean, threatening to stick a new Mossberg 12 gauge up someone's butt, and all of the things that just kept, I mean, as I'm
Horrific.
reading this, I'm like, it's horrific.
Yeah, no
And
question.
your argument seems to be, it's all horrible, but once the judgment's entered and 12 months pass, you're done. You can't ever go back and revisit that. And then further, it appears your argument is, this is an alimony, it's a permanent alimony, so then there's got to be a change of circumstances, and you can't even consider all of those things that happen. Is that basically your position on
It's
that?
not merely my position, it's what 12.540 says on its face. There has to be a basis. The only case law the court cited, which I think you recognize, and you're asking me something that's deeper, is Casto versus Casto. Casto isn't a case about trying to overturn a final judgment. It's a question about the effect of an agreement. But so you're stuck with 12.540 in their position. She not only knew of these facts, she experienced them. However, recognize she went to the Social Security disability hearing with him. So one wonders about that, but
She knew he had a
regardless,
disability and that he had this explosive personality.
she knew all these things. She knew all these things. She experienced them. It caused fear. The courts decided that. I accept that the courts decided that. Those facts are decided, but they have no legal effect because the last time it happened, according to the former wife's own statement, was 8 years before she stopped paying. And this rule says that you can only set aside a final judgment which has res judicata effect, as we all recognize, unless some provision is applicable. None of those provisions, none of the three possibilities are applicable in this instance, clearly, according to the record. So opposing counsel danced around this in the brief that was written, but they don't even address the Supreme Court case that says it's not a void judgment. That's clearly wrong. And I recognize that Judge Spohr was reacting to, as you said, horrific text, and judges want to do equity. This is not an equitable circumstances. We don't weigh the equities in this case once we have a final judgment.
Going back to your point, the 1 year, you said that was it. There's a year. Under your view.
Unless
of
there's
this
another
case-
provision.
Sorry.
It's a year. There are other provisions that allow for longer time.
Okay, but basically if someone is being harassed and harangued and then it continues, so they agreed to the judgment. And then behind the scenes, as we saw here, it continued for several years, where like almost immediately after it's entered, I see what you've done. We got to change this. You're going to screw me down the road. Don't forget, I'm going to come for you. All the things that you don't have to play back through them. But if it's presented later that the only reason they finally were beat into submission was from their fear, you're saying that even 12.5405 it's no longer equitable, that judgment should have prospective application that
I'm saying,
apply?
I'm saying the only cases that deal with that say it has to be an event since the final judgment. That's not what we're dealing with. We're dealing with events that were 8 years prior to the last bad act. She had remedies to her. She had law enforcement would be one remedy. She had the remedy of sitting in front of the judge and telling that judge at the final hearing, I think it was Judge Durance, if I can read the scribble correctly, that it was not voluntarily executed, recognize that that final judgment says it was. I don't have a transcript of that particular hearing, but that final judgment for in terms of orderly justice has to have effect. And that's why we have 12.540, which has clear provisions of when that may have effect. So you would be creating new law contradictory to other DCA opinions. I think in part, the second DCA, which used to control this geographic area, I recognize it doesn't have precedential effect, but it has important effect. That's what this law says in terms of it is no longer, which by its own express provision seems to imply something that's subsequent to the final judgment that we're dealing with. And what she's talking about are events that happened before she put pen to paper. So I would submit there's no law that supports the result of this judge. It's understandable given the equities, but we're not back in time. We'd have to go in a spaceship back in time. And if we went back in time and we were at a final hearing and she made
I
this.
get that. And I get your argument. What I'm asking, you seem to be arguing that under five, that second part at the end, consider all of the things that happened up to the time of the final judgment and for several years after the final judgment, and looking at the equities of whether this was voluntarily entered and whether payment should continue.
I would submit that the events that happened after the final judgment have no effect at all on whether she voluntarily signed the agreement before, because the events, so it would have to be back when this final judgment was signed in 2009. So if somebody coming and making all these twice monthly payments for 8 years after the last act, so you're talking about 96 payments that she made, 96 times 2, 192 payments that she made every month thinking about this, doing nothing. So I'm saying that this has already been decided in terms of these rules, and it's not available to her. So it's not merely my argument, it's the force of law and the force
Why
of.
wouldn't at least anything that happened in the first year or so matter? That's the period where under fraud, she could have made an argument that it was fraudulent.
Hadn't really thought about that because it doesn't really change it's a distinction without a difference, I think. Or
You said nothing after the final judgment, and I'm
Well-
asking, why wouldn't it matter for the first, at least a little bit?
it would matter for your issue, but in terms of whether she voluntarily signed this, it wouldn't matter at all. But in terms of whether those provisions might have effect, yes, I think you have a point, but it doesn't matter for our situation because these events allegedly happened for several years after the final hearing. But all the case law that I find supports the proposition that I'm stating. So I recognize you're thinking like the trial judge that you used to be and wanting to do equity. This is not an equitable
I'm trying
circumstance.
to understand your argument and apply it to how the ruling fit into the red in the future.
Mr. Customs, I'm curious, you said all the case law applying 12.540B5. We're talking about, which is no longer equitable, but the recognition of application. I didn't find a lot of case law on that particular section. I did find Schmidt versus Nipper, the first DCA 2020. And in that case, the court actually said an appellant must show that there are new circumstances at the trial court.
Right.
Which would kind of affirm what you're trying to say before the court today, which is there's got to be something new and different. We can't look back in the rearview mirror. But in that particular case, from a factual standpoint, there was nothing that happened post judgment. What concerns me and what I believe distinguishes our facts here is we do have something post judgment. And so, I have to put myself in in the bigger grand picture here of, okay, so somebody gets a judge, somebody does exactly what appears to happen on paper here, which is threatens a person into signing off on an agreement, or I'm going to kill you and the kids. Okay, I'm going to sign it. That gets entered by the court without any litigation, without any discovery, which I think does distinguish it from the McCarr case, at least, because in McCarr, there was a lot of discovery and therefore they said Casto doesn't apply, but I don't think we have that here. So I have a hard time applying McCarr, but I don't have a hard time applying 12.540. So I'm still with you on 12.540. But my challenge is that I don't see a Schmidt versus Nipper, the one is to look at. In Schmidt versus Nipper, the facts were done. There was no talk of threats continuing after the date of judgment. And again, big picture perspective, somebody gets a judgment and they have an extreme situation where they're threatened at gunpoint, held in a basement for 365 days, or like in a situation like this, threatened the life of you and your children. Is that enough for us to say, no more prospective application of this judgment? This is a situation where there were things that arose after the judgment, which were threats by one party against another that prevented that party from going to court, prevented that party from doing what we would expect them to do, exactly what you're saying, finality of a judgment and all that. Is this one of those situations where we could say under these facts, no, there are some facts that arose after it, and they're called the threats of one of the parties, and therefore it is no longer equitable that the judgment have prospective application.
Okay, so then I would think, under your construction, struggling to find an objective answer, 12.540B3 says not just fraud, it says misrepresentation or other misconduct of an adverse party. And then you go down to the paragraph after 5, which defines this, and it says the motion must be filed within a reasonable time and for reasons 1, 2, and 3, not more than 1 year. So using your query, I would think that the time frame after the last act would start over for a year, essentially it would toll, like a statute of limitations. This is 8 years. And each month
to me, I would feel more like I was legislating from the bench if I took what you're saying. How are you coming up with that construction that with each act we get an extra year?
I'm struggling to find.
I don't see that. I mean, to me, I've thought that argument through, but I thought I don't see any support for that in the text. That
then I think you're stuck with the year. I'm stuck
with the year. Well, let's talk about that though, Mr. Sessoms, with the top 3. Okay, so at least the top 2, 1 and 3, the ones that are most relevant here: mistake, inadvertent, surprise, excusable neglect, fraud, misrepresentation, or other misconduct. Aren't all those actions that would have resulted in the judgment, not actions that took place after the judgment? Are there any cases that talk about fraud after the judgment, or is this all? For instance, if
nothing that talks about action after the judgment.
Well, I mean, so somebody agrees to some sort of consent judgment, and then 2 years later, I tell you I'm going to sell you a candy bar, and the wrapper's empty, and you say, oh, you just committed fraud against me. I'm going to go back on that judgment, that consent judgment from 2 years ago. All I needed was fraud, Judge. He committed fraud. He sold me an empty candy wrapper. That house sale that we agreed to is now off because of fraud.
Judge,
you can't make that argument, right? I mean, it's got to be fraud related to the judgment.
Correct. The judgment is the critical issue. You have a year under 1, 2, and 3 to take some action as it relates to the judgment, not as it relates to conduct after that. The only thing the conduct afterwards may have done is make her wait to do something, which she does 8 years later. But there's no provision, 0. So unless you're legislating from the bench, with all due respect, there's no basis to do what you were suggesting because of the language of the only thing that says that there's no time limit for motions based on financial affidavits. That's it.
Mr. Sessoms when they say something like, when I stop getting paid, I will have nothing to lose. I'll have no reason, and it goes on to threaten death. Isn't that an issue for the trial court to decide at what point she may have continued to be in fear? You're saying there's like a 1-year time frame. That's it, cut it off. I think that's an issue for a trial judge to look at and decide under the second part of sub 5, It is no longer equitable for the judgment to have prospective application. But why is there a 1 year time frame?
I didn't say that it was a 1 year. I said that for
You said
the issue of 5, it has to be done based on future events, not because we're talking about the
yeah,
judgment.
you said if there's nothing else that can be considered, then you're stuck with the 1 year on that. And if I misunderstood.
I'm
you.
saying that what 12.540 is dealing with by its very nature is whether you can set aside a final judgment, not conduct after the final judgment. So you're dealing with the issue of the agreement, which is what the former wife does in her brief. She totally ignores the fact that we're really dealing with a limited set of circumstances that a court can change a final judgment. So events that happen after the final judgment may be reprehensible, they may be criminal, but they don't allow one to set aside a final judgment that they sat on their hands for, apparently because of a reason. You have a remedy.
Just don't know that's the question.
I'm sorry.
Well, I think it may have been answered, but it just goes back to subsection 5, which we've been dealing with, and the fact that there is case law. Judge Smith talked about it. I know pure H2O is there, and I believe there's one other case. They all seem to be DCA cases, and binding precedent. And I think you may have answered it, but if you can hit it again, why are those cases correctly decided? That when we look at those cases, we should hold that the no longer equitable subsection of 5 is for matters arising after the judgment, not circumstances present during the judgment.
Because the language in and of itself, when it says no longer, relates to events that have happened since entry of the final judgment. These events, what we're talking about, were 8 years before the former wife took action. There's no basis for doing that because it has to have been done, quote unquote, within a reasonable time. 8 years is not reasonable under the case law that we cite in our brief. So we would suggest to you that not just the Napper case, but the other case law would suggest that if you sleep on your rights, 8 years later, you file it. Why couldn't you have done that earlier? There's no basis for overturning it under this limited rule.
Real quickly, I have a question. Your position is that even though in the agreement it said would be no alimony, that this is alimony, discuss that.
Well, the interplay between section 71 and 215 of the Internal Revenue Code allows one to change the designation. It's done all the time in common practice when when alimony was deductible and includable. So the 71 says you can deduct it, 215 said you can include it before the law changed. So it expressly allows you to change that. There's a Florida Supreme Court that recognizes that. This is not unusual in any way, shape, or form. So all of the criteria that make it walk like a duck, quack like a duck, et cetera, in terms of alimony are there. It clearly was support purposes. It's not unconscionable based on the record, based on the fact of the long-term marriage, and she clearly had the ability to pay it based on her own financial affidavit. And there clearly was a need based on the expenses, not just the former husband expressed, but what the former wife expresses in her affidavit.
We'll give you your 2 minutes.
Thank you. I appreciate
We'll
it.
give you a question.
May it please the court, again, Jeffrey Burry on behalf of former wife. Yeah, in this case, we have a unique set of facts and a very specific set of facts. The majority of those facts were undisputed and unrefuted at the trial court level. We believe that we moved to set it aside under Casto, which has 2 prongs, the duress prong and also the unconscionable prong going on discovery, and we'll go into that. We also moved to set it aside on a fraudulent financial affidavit, which has no time frame under 12.540.
Did you stand here today and move to set it aside under Casto? Is Casto applicable to this case?
Yes, and so we need to look at McCarr. I understand that McCarr deals with a different factual scenario, but you have to look at what the ruling of McCarr is. So this is the certified question to McCarr. Whether a final judgment, which incorporates a marital settlement agreement achieved after commencement of litigation and marriage dissolution actions should be subject to challenges based on Casto or should be solely predicated on Rule 12.540. So right there, the Florida Supreme Court is there's 2 standards. You have a Casto standard for the agreements, and then you can also set aside under Rule 12.540. McCarr said,
Counsel, doesn't that make more sense when you look at the nature, the posture of the proceeding? I mean, Casto, they talk a lot about their arm's length, things like that. We may have duress have a different standard when we're not in the middle of litigation with our discovery, and all that's interesting. But why does the final judgment not cut this off? It no longer becomes about a private contract and how you may, and whether or not you should set aside a private contract, but the limited grounds upon which you should set aside a judgment.
Well, I think that the Florida Supreme Court could have answered that. They could, with that certified question, they could have said every marital settlement agreement that is incorporated in a final judgment, you're limited to 12.540. And the Florida Supreme Court did not say that. And instead, it carved out and said that if you have proceeded the procedural posture of the McCarr case, if you are at arm's length, if you have counsel, if you had a year of discovery, then you cannot seek under Casto. You are limited to 12.540. So the Supreme Court has given you that there's two standards. Otherwise stated, the case here that we have before us doesn't reach the procedural posture of McCarr. So you would be able to go under Casto. The Florida Supreme Court could have just said that. It could have said every MSA in a final judgment, you're done. But it didn't. And again, we have to go with the court of equity and look at the very facts of the nature. And if you even think about like Petracca was a case where it didn't even go to a final judgment. There was 2 weeks prior to the trial, the parties reached an agreement, and before final judgment, they set it aside and they said, there's lawyers, there's discovery, you've reached a procedural posture, so you cannot set that aside, that agreement under Casto. So that's before a judgment.
No, absolutely, but they provide a different analysis than CASA, which is looking like before, you may be pro se, you may not have discovery. Petracca is saying, now you've had discovery, maybe we don't set aside the agreement, but they're not reaching the ultimate question of the judgment.
But I do think that with the McCarr, it's
Makes sense.
and then if you'll get a post-McCarr case, there's a case that we cited called SUPA. So that was a case of MSA, very similar facts. No attorneys, or there might have been one side had an attorney. MSA, petition, judgment, bam, 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 an uncontested case. They moved to set it aside, and the court, a post-McCarr court, used the Casto standard. And again, that was an MSA that had been applied, incorporated in a final judgment. So it wasn't limited 12.540.
SUPA is not binding on us, and there's multiple ways to read it, correct?
I agree it's not binding. We are citing it from the standpoint that it's not just a blanche MSA final judgment, you're done. You have to go under 12.540, which I do. And I think that the way we present the case is that you have Casto, you have 12.540. I think that we aren't against the language of 12.540. Section 4 and 5 don't have a strict 1 year time limit. It's reasonableness. It's fact and sense. And again, the trial court, when you look at the order in this case, there's significant findings. The court took thought and deliberation. The trial court has the vantage point to the demeanor of the witnesses. There was findings of duress up through the time of non-payment.
Well, counsel, let's travel through 12.540 and see where these findings. Let's start with the subsection 4, with the final, that the judgment is void. Here, you argue that the marital settlement agreement is void, but does that mean that the final judgment is void? And what case can you cite for that support, that just because the marital settlement agreement may be void, the final judgment is void?
Well, Your Honor, if the marital settlement agreement is void and it's then a void contract's non-enforceable, I think under 4 or section 5, it would have no prospective effect. You have no underlying MSA.
It's shelter judgment.
Well, again, going back to McCarr, there's 2 standards. The Florida Supreme Court has answered and said that if you do not meet the procedural posture, it even says, and there's a footnote 7 in that case that talks about this ruling to limit a party to 12.540 on a marital settlement agreement, a court of equity, is limited to the procedural posture of this McCarr case. This opinion limits to that. The concurring opinion of McCarr even says that we're only limiting to these facts. So again, the Florida Supreme Court is not denying a party from setting aside a marital settlement agreement under Casto. They could have answered and said, no one gets to set aside a marital settlement agreement incorporating a final judgment because the res judicata effective final judgment. The Florida Supreme Court did not say that. They had that opportunity, and they clearly recognize there's these 2 standards. It is very fact-based.
So if we reject your argument that Casto applies and we find instead that relief from judgment should have been governed by the rules of procedure, can the trial court's order stand? And how?
Yes, I think it can stand again under, if it is a void agreement, which again is factually based on the duress and the terms, the one-sided nature of that agreement. If it's void, I think that under 12.5 for the section B4 or B5, it can be affirmed. Those do have a reasonableness. There is it does say reasonableness in the rule, which that would be for the trial court, and based on the facts of the duress before and afterwards, the trial court could find that that was reasonable, that this 8-9 year delay was reasonable. We don't think it's a delay.
But doesn't 5 have prospective application? And the trial judge here went back to an order in that paper. So would it be a different analysis for us if the trial judge had said, what's happened here?
Well, I think that ruling, I mean, if you, the way the order is now, there's still reservations. So the question of where are the parties? Are they back at the original divorce? I think that would be a question for further argument in trial court. Is this going forward from that date of that order that she's relieved from that obligation, or does it go back? And is there an argument that she can disgorge that money, or if there's alimony that's reset or some sort of money reset, would it be offset against that? So I think it could be, it's not quite litigated there yet from that standpoint. Others, I don't know if that argument wasn't made up in the trial court. I think that would be for the next stage of the case on the
As it sits here today, we have to make that decision.
Yeah.
Whether we can apply 5, because it's clearly by the wording is prospective in nature going forward. And but you're recognized, you can continue with your argument.
Going back to the question about if Casto is off the table, this 12.54. So we had the void. So you have section 4 and 5. I think with also the duress, you would still have the section 5 of going it's a court of equity with the facts. And then we also have the fraudulent affidavit argument that wasn't ruled, it wasn't denied, it wasn't ruled upon in the order because the judge ruled on the Casto and the lack of consideration, but that would still be on the table too. So we think that was supported to set it aside under 12.54B5. And I know I'm coming up, and I'm sorry. I know that I'm coming up here and saying there's these 2 standards and pick one. Which one are you picking? We believe that that we're not against any of the language of 12.54. I do believe that under McCarr, that in this marital settlement agreement, that with the facts of this case, that Casto can still be applied to set aside the agreement. If you set aside the agreement, I think the new fact under 12.5 would be that the agreement's gone. And so the final judgment then is no longer applicable. But even if you look at 12.540, again, going back to McCarr, the appellant wants to argue that section 3, that we're bound by this section 3. And so everything has to be within 1 year. Casto's broader. The first prong of Casto doesn't require fraud. Fraud's one of the issues, but there's duress, there's coercion, overreaching. The second prong of Casto is not in 12.54. So 12.54 is a broader test. I mean, that's what McCarr and the Florida Supreme Court said. Do you get the broader test if you have the procedural posture of McCarr? No. We don't have that in this case. And so with that broader test, we do believe that we can go under Casto. We don't think that section 3 applies for this 1 year limitation. And then think about that from these events, this duress that enters this one-side agreement. The duress continues. So based on appellant's argument, as long as that former husband for 366 days continues that duress, bam, he wins. He's got a windfall unnecessary. You can't do anything about it. No, again, that's a court of equity, and that's why Casto applies. And there's not case law that wouldn't say that Casto applies. You can read McCarr and it shows that it does apply. McCarr says you're bound by 12.54 under these circumstances. We don't have those circumstances in McCarr. So you have the ability to go under the agreement under Casto. They could have said every final judgment that incorporates an MSA, you're done. And they did, they chose not to. Real quickly on the void, there's an argument about it that it's a voidable final judgment and that would need to be brought in a year. And the case that the appellant cites in the brief was Williams' case. I just wanted to point out the Williams case involved where a parenting plan didn't match the terms of the final judgment. So there's an inconsistency. The party waited 4 years. They argue that that made the final judgment void. And then on the appeal, they said, no, that only made it a voidable judgment, needed to be brought in 1 year. That really is 12.54B1. It would be a mistake. And so that Williams case, we don't think is applicable. That
What about Tannenbaum versus Shea? Out of the fourth BCA. They say similarly in this case, even if the agreed order's divestiture of jurisdiction over the money judgment was void as against public policy, the order itself was merely voidable since the trial court had personal and subject matter jurisdiction over the parties and there was no due process violation. They seem to be analyzing the judgment being void, right? Under
yes, sir.
personal jurisdiction, is there subject matter jurisdiction? If we have a due process violation. They seem to analyze that different than whether or not.
And that would be a case law if you under just a void agreement. If you think about setting aside a default judgment when 20 years down the road, if there was no service of process, no due process. We have a situation where, again, also, as you'll see in the brief, we don't think the void or voidable makes a difference from the ruling the court made. But if you have it where the agreement is void, we get interchanged with the agreement and the judgment. If the agreement is void, then the final judgment would be void and it could be set aside under 4 or 5.
Why?
Well, under 5, it'd be no prospective. You shouldn't have a final judgment with prospective application on an agreement that is unenforceable. If it has lack of consideration, it's unenforceable. So 5 would do it. And then the void would be a void agreement, would then make the judgment void.
You're saying you can go into 5 and use the words prospective application, go back to the time and go forward. No longer equitable, the judgment should have prospective application. That would be from today forward, not going back to the time of the judgment and looking forward.
And again, not to stress regard, again, if we do believe that you can set aside the agreement under Casto. So if you do set it aside under Casto based on the duress, Section 5, the agreement is set aside so that the final judgment would have no prospective application for that agreement.
What about the argument that what do you have to say about the time frame and the ratification argument?
So the ratification, and we've cited the case law, if a contract under duress gets entered and the duress is continuing, then you cannot ratify the contract during the time that the duress is continuing.
In this case, it didn't continue past a couple of years, arguably.
Oh, we assert that if the final, at the hearing, the wife testified that her fear was up to the date of non-payment, that she had fear that day. The trial court, again, was in the position to evaluate those witnesses. And in the findings, it found that the fear was there. So we think the duress continued up to that point. I do question, the ratification in family law. So if you have a prenuptial agreement that was duress or could be subject to a Casto attack, and then 10 years later, they entered a postnuptial that ratified that, I think then maybe you could have ratification. I just don't see even a ratification of a former wife, paying pursuant to an order in a family law case. They haven't cited where in that situation that would be ratification. The family law cases really are prenup with a postnup ratifying that original prenup. I don't think that her action to pay pursuant to a court order under that duress would amount to a ratification.
So, Casto, 1987 case, 1984, Florida Rules Civil Procedure was applicable to family law cases 1.540 at that point in time. So they could have mentioned 1.54 if they wanted to, but they didn't. In McCarr, I know you're saying that effectively that McCarr makes Casto applicable outside the realm of any time restrictions that are in 12.540. But as I look at McCarr, it was filed within the 1 year after the judgment. So judgment gets entered and then they file the motion within a year. So there's no, what I would read McCarr, I think is the proper read of McCarr is that Casto is a basis in the legal sense as you're raising it, but it doesn't avoid the time limits that would be under 12.54. You might be sensing that from my colleagues as well. But let's just say we did follow your argument in regard to Casto and that challenge could be raised at a broader time perspective than 12.540 currently provides. What is the time limit? If we accept your argument, and now that's the law of the state of Florida, and we write an opinion And we said the trial judge got it right. Casto applies, over 10 years after a final judgment's entered on an agreed marital settlement agreement. How do we read a time limit? How do we write a time limit into that? What would be the time limit?
And I think it's going to be a case by case basis. If you think about McCarr, it avoided a bright line rule. It said you have to look at the case at procedural posture. Petracca looks at that, no bright line rule. It doesn't say McCarr only applies after judgment. It applied McCarr prior to a final judgment. SUPA, no bright line rule. You have a final judgment, you can set aside Casto afterwards. We cited an Arkansas case, Grover, that does apply Florida law. And in that case, they said the argument was that McCarr, you can't use Casto when litigation's going on. McCarr says so. And they evaluated and said, no, the posture of the litigation that reached a McCarr. And in that Grover case, the litigation won there. So I really to point out is that there is no bright line rule, a 10-year, 8-year. You have to look at the facts. The trial court has to look at those facts. And these are unique facts. This isn't a case you get, it's not going to be a million of them.
I
It has a
understand.
very specific fact. And so the trial court needs to look at it.
And I'm going to give you a chance to respond to this. I understand the whole case by case basis, but if we write this and it becomes the law in the 6th DCA, other trial judges are going to have to be able to look at our opinion and say, this is the standard. And from what I'm hearing, you haven't given me a standard yet. What would be the standard that we would set as the time limit?
Well, I think, again, I think that's
12.540.
And we're not trying to argue that Casto is exclusive to 12.54. This whole case, we believe that we've combined with both of them. There is a reasonableness time frame in 12.540. And again, just a case by case is it reasonable? Is there a situation where someone could enter an agreement during duress and wait 10 years and it wasn't reasonable?
So we just,
No,
the standard would just be reasonableness. We just say, trial court, all the litigants in the 6th DCA, as long as it's reasonable, no more guidelines than that as to whether you have a final judgment.
It would have to be a case by case basis. Right now, so there is, since entry of McCarr, there's not a case that says Casto has to be presented in a blank year. And we're asking that the court affirm it with that affirm. And we believe that the judge, that the ruling was based on competent substantial evidence, and that we think that under all the arguments, whether it's Casto, the lack of consideration, the fraudulent affidavit, which has no time bar, the 12.54 section 4 or 5, even without a Casto. But we do think that Casto goes together with it. You set it aside under Casto. If you look at the order, the court heard
a couple minutes to finish up.
the court heard the evidence, set it aside under Casto, and then they would have the right to set aside the judgment after having set aside. And again, just to touch on it, like I said, under the appellate's argument that you have this duress, a one-sided agreement, the former husband wouldn't have been able to get any of this relief under a court of law. It's saying, hey, let's get this divorce done, let's get this divorce done, gets the duress continues all the way up to through the hearing. That's found that under their appellate argument that somehow if he made it 366 days, then he gets this windfall and he's it had succeeded. That's not, we just don't see how that would be how society is.
Somehow you're told that it's a windfall that my client was to receive essentially permanent alimony in a 26-year marriage where he makes 1/10 of what she ultimately made by taking his non-marital assets and getting a bachelor's degree and 2 master's degrees. When you read it on the face, it's essentially what you would expect in a long-term marriage, that he gets support of 40% of her net income. She gets the balance. She gets 60% of her net income. It's not an unusual result. I don't know how that would determined by the court to be unconscionable, but there's no grounds for that. So you're told a very vague standard of there's no law on this. There is law on it. Harvard Financial Services from the 3rd DCA from a 2019 case said a motion to vacate a void judgment. That's a void judgment, not what we're dealing with. Nearly 8 years after the issuance of a dismissal for lack of prosecution was not filed within a reasonable time. So reasonable, you have to take a step back and say, how could, as Judge Smith indicated, how could you construe that this somehow is reasonable? Why did her fear suddenly dissipate sufficiently 8 years later that she was able to file this action? So would it if she showed up 15 years later, would that make sense? So given the fact that you can't even wrap your minds around a standard that makes sense, it shows how nonsensical this argument is. I would submit to you.
There's my hop in with a quick question. I know I had asked you this originally, and I think I sidetracked you with too many sidetracks on the question itself. But let's take this hypothetical, which unfortunately is not too far off the facts of what we have here. So final judgment gets issued, and you know, a bad actor party holds the other person captive in their basement for 366 days and then releases them. Is there any basis under what under your reading of the law? Is there any basis for any basis?
I think in that particular situation, you could construe it, even though it doesn't say it with any precision. The motion must be filed within a reasonable time, except there will be no time limits. I'm sorry, under 5, the last clause. It's no longer equitable that the judgment should have prospective application. It's no longer equitable because she just got out of the basement. So that event happened after the final judgment, but I think in that particular situation, you would construe it akin to a tolling statute. When it runs 8 years, it's too long, and we have the Harvard financial case to deal with that. Recognize this judge in
So that would be under 12.540B5 last.
Correct.
Sentence, correct. Okay.
Correct. Recognize this judge says herself, I waffled on this 4 times. The paucity of her findings in her transcript indicate that she was swayed by these emotional, equitable facts and not the law. There's no basis to find this, avoid the restatement of contracts, and the cases that we have are very clear that this is at most avoidable. I'd also encourage you to deal with the issue of fees and costs, because that wasn't dealt with by the court at all. Thank you. Appreciate your time.